Welcome to Legally Speaking with Rest the Case, where we break down complex legal topics into insightful discussions with industry experts. Today, we're diving into arbitration in India, a faster, more efficient alternative to traditional litigation. But is it truly as effective as it seems? To help us navigate this evolving landscape, we have with us Advocate Sidhartha, Senior Partner at Auromaa Associates, who brings 16 years of expertise in intellectual property, arbitration, and high-stakes litigation across courts in India. Advocate Sidhartha, thank you for joining us today. To start off with, what sparked your interest in arbitration, and how did you build your expertise in this field?
See, my interest in arbitration was sparked by its efficiency in resolving complex commercial disputes without this lengthy litigation process. And I built my expertise. If you see over a period of years, I saw there are many cases which came up to me where it could have been settled through mediation, but then people went through long litigation processes, and therefore I plan to shift my expertise to a part of it, in fact, expertise in IP litigation to arbitration, and built my expertise through specialized certifications from WIPO. I'm a WIPO certified arbitrator and mediator, and International Chamber of Commerce certified arbitrator. Then I have a lot of hands-on experience on IP disputes and continuous engagements with emerging trends in the alternate dispute resolution. That's how I built my expertise.
Right. So, it's right now arbitration has been gaining quite popularity in India. But can you tell us a little bit about what's the current scenario of arbitration in our country today?
Yeah, sure. See, arbitration in India is gaining momentum as of late as a preferred dispute resolution mechanism. Yeah. If you see, especially in the commercial and the IP litigation. But then the Commercial Act 2015 was also passed to perk up the commercial litigation process. If you see the legislative reforms which have come in 2015 and 2019, the amendments which have come in this Arbitration and Reconciliation Act, actually they have strengthened its framework by reducing delays and promoting institutional arbitration. However, if you see, categorically judicial intervention and enforcement challenges continue to hinder its full potential. If you see Singapore or maybe other, there is less of judicial intervention. But here in India, you'll find a lot of judicial intervention, as in Section 34, Section 37, all this getting filed. Greater adoption, and I feel greater adoption of institutional arbitration and clearer enforcement mechanism are key to the future growth of ADR in India, basically.
Right. So do you think that more involvement of judiciary is one of the challenges that arbitration...
It's one of the biggest challenges, ma'am. It's one of the biggest challenges, because an arbitral award is given and then you see the Section 34, again you go into the litigation process. Correct. It's a long litigation process. So it again hampers the entire framework of the ADR.
Yeah, so usually we take ADR to escape the lengthy process of the court, but here we are again in that same loop where we're again
having same loop.
Right. So are there any other challenges to ADR which makes it a lesser used option, or what do you think are other challenges which arbitration faces?
Normally, ADR was devised to be faster and more, cost effective than litigation. But it is not always the case. As I said, challenges like excessive judicial intervention, delays in tribunal appointments. Okay, I mean arbitration tribunal appointments and high arbitrator fees can increase the time and the costs. Okay. Then there are procedural inefficiencies which also occur, frequent challenges to awards that Section 34 I mentioned earlier, and lack of institutional arbitration further contribute to these delays. Streamlining processes and promoting institutional arbitration, in my view, can help address these issues.
Right. So, the Arbitration and Conciliation Act of 1996 was definitely a game changer when it was enacted. But do you think it's still effective today, or what are the updates that it needs now in today's day?
1996, of course, the Arbitration and Conciliation Act 1996, of course, laid a strong foundation, and the amendments in 2015 and 19 improved the efficiency by limiting judicial intervention and promoting institutional arbitration. However, challenges like delays in enforcement of awards and lack of uniform institutional arbitrational rules still exist. In my view, further reforms, especially in award enforcement, tribunal independence, and procedural clarity, are needed to make arbitration truly effective in India. For example, if I say time-bound enforcement arbitral awards, courts should have stricter deadlines for disposing of challenges to arbitral awards to prevent unnecessary delays. Otherwise, normally what happens? These delays go on, as in India we say, I'll just use a bit of Hindi over here. Date per date and all those kind of date after dates that happen. And then we have to have clarity on confidentiality and third party funding also. The law should explicitly address confidentiality in arbitration proceedings and regulate third party funding to promote transparency and accessibility, in my view.
Right. And how do we ensure lesser intervention of judiciary? Since you mentioned that was one of the biggest challenges, is there any way to make sure it's lesser?
See, judicial intervention. See, the courts play a crucial role.
Yeah.
Because appointment of arbitrators, enforcing awards, and handling challenges under the ANC Act 1996. It can be said that. I can say that judicial intervention is necessary to uphold fairness. Excessive interference, but the excessive interference often leads to delays. Going forward, courts should adopt a pro-arbitration approach, limiting intervention to procedural and jurisdictional issues while ensuring swift enforcement of awards to strengthen India's arbitration framework.
Okay. And now, in today's world, we're moving to more technology being used in our courts or everything. So how is that changing arbitration in India? Do you think we're moving more towards virtual hearings, online dispute resolution? How do you see this evolving?
See, we are, to be very precise, we are not even near the birth of the AI. Right. As far as arbitration or these things are concerned. I'll give you an example. In arbitration, there is something known as case management. Okay. Now, if you see, no doubt this technology is helping arbitration in India by enabling virtual hearings, online dispute resolution, and things like that. But AI is still nascent. In India. But this can be used for AI assisted case management, making the process faster and more accessible. Virtual hearings have become more common the post-pandemic area, that is the 2020, reducing cost and logistical challenges. But then still, if you see, sometimes you don't have the link and everything. So sometimes those things do happen. Then AI-driven tools also are also emerging for legal research and drafting, which are still at the nascent stage, as I told you, though their adoption and decision making is still evolving. So these advancements are gradually making arbitration more efficient and tech-driven, but there's still a lot of way to go.
Right. So, do you think that AI or blockchain technology, these technologies, is essential for arbitration moving ahead?
Yes. But if it is implemented properly, arbitrators, maybe the judges, everybody needs to be sensitized. Everybody needs to be made aware, needs to have knowledge about this blockchain technology, because I feel it can enhance arbitration by ensuring transparency, security, and efficiency, no doubt. Then blockchain technology can create smart contracts which can automate enforcement of arbitral awards, while you see the blockchain's immutable ledger can securely store evidence, agreements, and procedural records, reducing disputes over document authenticity. This can increase trust in arbitration, as far as I feel, by minimizing tampering risk and enhancing procedural integrity.
Okay. So I'll also move towards a little bit towards the arbitration institutions that we have in our country currently. So just for an example, we have like Delhi International Arbitration Center or Mumbai Center for International Arbitration. Do you think that these institutions are doing enough to promote arbitration? Do you think there's more need of promotion in our country?
You can say DISC or Mumbai MISC, unlike SIAC or even London International Arbitration Center LIAC, they have, they have played a crucial role in promoting arbitration in India by making structured rules, by providing structured rules, trained arbitrators, and global recognition. But however, I think there is more to be done to enhance the impact, such as increasing outreach programs, improving case management efficiency, and fostering greater adoption of technology. Additionally, efforts to reduce procedural delays and enhancement of institutional credibility can further strengthen India's arbitration landscape.
Right. So, but do you still think that, even though we have arbitration systems in India, do you still think people choose to resolve these disputes abroad? Is that still something that happens?
See, you are making a comparison over here with LIAC, SIAC.
Yeah.
Now Dubai is coming up as an international arbitration hub also. So to compete with this, I feel India must focus on ensuring judicial non-interference, which is very, very important, because courts should adopt a more arbitration-friendly approach, limiting excessive interventions and ensuring speedy enforcement of powers. That's one.
Right.
Secondly, India should strengthen its institutional arbitration. Okay. Like International Chamber of Commerce is an institution, so institutional arbitration should be strengthened because these organizations like DISC, MISC, they need greater global recognition, streamlined procedures, and experienced arbitrators. Then we have to improve the infrastructure and technology, because developing world-class arbitration facilities and adopting AI-driven case management can enhance the efficiency. So we need to improve upon our infrastructure and technology. And there are a few amendments to arbitration law that should be made, ensuring minimal delays, cost efficiency, and party autonomy will make India a preferred arbitration hub in the near future.
Right. And if you had to give any advice to businesses who want to enter into arbitration, what should they ensure to, make sure the process is smooth and efficient?
Do you mean to say the legal system to attract investors or something?
So yeah, even that we can talk about a little bit. So, like we were mentioning about India promoting arbitration, but there are still significant delays and the infrastructure is weak, as you also mentioned. So do you think that the legal system is ready to attract more cases, or is it just to attract investors into the system?
Right now, India is proactively or actively promoting arbitration is to attract investors.
Right.
Because systematic delays and weak infrastructure remain the key challenges in our system. No doubt the legal system is evolving, but enforcement bottlenecks, judicial interference, and lack of experienced arbitrators still hinder efficiency. Okay, we have courses on arbitration and everything, but I take up a course in arbitration, for example. So, am I eligible for handling an arbitration? Am I eligible as an arbitrator? So, what more can be done about it?
Right.
Okay. Then, without stronger institutional support, quicker enforcement of powers, and better trained arbitrators, arbitration in India is at a risk of being more of an investment pitch than a truly effective ADR, dispute resolution mechanism.
Right. So then also, when we also spoke about how the judicial intervention is a major concern, so is it fair to say that judiciary still holds too much power in arbitration cases, and somewhere it undermines then the concept of alternate dispute resolution?
See, I'll say the balance between the judicial oversight and minimal interference in India is still skewed. And unless courts adopt a truly pro-arbitration stance, arbitration risks becoming just another layer of litigation rather than a true alternative to the court proceedings.
Right.
That I believe. Though, as I said earlier, though courts play a crucial role in enforcing awards and ensuring procedural fairness, but frequent intervention, especially in challenges to arbitral awards, often defeat the purpose of arbitration as a quick and final dispute resolution mechanism.
Right. And so if we talk about businesses considering arbitration as a means to resolve disputes, what would be your key advice to them to ensure that the process is smooth and efficient?
First and foremost, please draft clear arbitration clauses, which should categorically specify the seat, the governing law, and the institutional rules to avoid any kind of ambiguity. Then choose experienced arbitrators and ensure well-documented agreements that can prevent unnecessary delays. Then embrace technology-driven solutions like virtual hearing, AI-assisted case management approaches. They can improve the efficiency.
Correct. And what are the common mistakes that people or enterprises usually make when entering into arbitration?
That's why I already mentioned.
Yeah.
They should draft clear arbitration clauses. So vague and poorly drafted arbitration clauses, failure to specify the seat of arbitration, and not defining the governing law clearly are the common mistakes which normally people do.
Right.
People often tend to overlook institutional arbitration rules, leading to procedural confusion. In my opinion, to avoid these pitfalls, agreements should be precisely drafted with expert legal guidance, ensuring enforceability and smooth dispute resolution.
Right. So let's then talk about a little bit about the future of arbitration in India. How do you see the future of arbitration in India? Do you think we're moving towards a more reliable ecosystem of arbitration?
Yes, you can say it looks promising, no doubt, because with greater adoption of technology, virtual hearings, and as I said, AI-driven dispute resolution, it makes the process more efficient.
Right.
Then we have global collaborations and institutional reforms are also strengthening India's arbitration framework, which is actually moving it towards a more robust, transparent, and internationally competitive ecosystem.
Okay. And do you think that arbitration will eventually ever overtake litigation in India as the primary method of dispute resolution, or will they coexist in the future?
See, I'll give you a small example before I answer this question.
Yeah.
You have a trademark XYZ.
Yeah.
And I have a trademark XYZ. Okay, now, where is the scope of arbitration over here? There is no scope. Yeah. Either you are in the market or I am in the market. And the person who is prior in the market will ride over the other person. Okay, so here there is no scope of arbitration, but yes, there could be a scope of mediation over here. Given the circumstances of the case, peculiar circumstances of the case, there could be a mediation over here. But now coming back to your question, suppose I killed a person, I murdered a person. Okay, so what will arbitration do over here? Arbitration cannot do anything.
Correct.
Okay, that's entirely out of the question. So, answering your question, arbitration and litigation will coexist in the foreseeable future, as not all disputes, as I said, are suited for arbitration. While arbitration is gaining traction for commercial and cross-border disputes, but litigation remains essential for constitutional, criminal, and public law matters. However, with continued reforms, if we follow those continued reforms, arbitration may become the preferred choice for business disputes in India.
Yeah, correct, got it. So I had two more questions about, what is your advice or recommendation to improve arbitration, and also what should businesses do? But we've kind of already touched upon that. So I would rather ask you if you have any closing statements, if you have anything final to say
Yeah, well,
before.
the first answer to your question is still the same. Limit, there should be a limit to the excessive judicial intervention.
Yeah,
There should be a minimal interference policy or principle under the ANC Act. And but the second point is strengthening the institutional arbitration and streamlining enforcement of arbitral awards would
yeah,
also enhance the India's arbitration ecosystem. And people who are trying to get into arbitration, they should draft clear and precise arbitration clauses to avoid ambiguity and future dispute. They should choose a reputable arbitration institution, specify the governing law, seat of arbitration, and procedural rules upfront, because that will ensure a smoother and more predictable process.
right. I think that was an incredibly insightful discussion on arbitration in India. I mean, I think we explored its advantages, disadvantages, challenges, what is going to be the impact of technology, what the future holds for ADR in our country. So before we wrap up, Advocate Das, I would like to thank you for being here. And thank you so much for your time and expertise. Your insight have been really invaluable. And this has been such an interesting conversation. To our listeners, if you found our discussion helpful, don't forget to subscribe and stay tuned for more episodes when we bring legal clarity to real world issues. Until next time, stay informed and stay empowered. Thank you so much.